Commissioner. Hearing is now resumed.
Good morning, Mr. Commissioner. It's Patrick McGowan. With me is Jennifer Chan. We're counsel for the Commission. This is the first day of a 6-day block of hearings focused on topics related to Aboriginal fishing. Today, Dr. Harris will be examined by participants on a paper he has prepared for the Commission. Over the subsequent 5 days, you will hear from 3 panels consisting of witnesses from the Department of Fisheries and Oceans and members of several of our First Nations participant groups. I'd like to start this morning by marking the Commission's policy and practice report on this topic. If we could have the first page of that brought up on the screen, please. Yes, Mr. Commissioner, this is a policy and practice report prepared by Commission Council. It's titled Policy and Practice Report, Department of Fisheries and Oceans, Policies and Programs for Aboriginal Fishing. It's dated the 2nd of December 2010. This report was distributed to participants late last year, but it has not yet been entered, and I'd ask that it become the next PPR.
It'll be marked as PPR number 18.
So, Mr. Commissioner, we have a single witness today. It's Dr. Doug Harris. You see him seated at the witness table. We're going to seek to have him qualified as an expert in the legal history of Aboriginal fisheries in British Columbia. I'll start by taking you through some of your background, sir. If we could have the witness's CV on the screen, please. Morning.
Solemnly affirm that the evidence given by you to this hearing shall be the truth, the whole truth, and nothing but the truth.
I so affirm.
State your name, please.
Douglas Harris.
Thank you. Counsel.
Dr. Harris, you have a PhD in law with a focus in legal history, is that correct?
Yes.
And your PhD dissertation was titled Land, Fish and Law, The Legal Geography of Indian Reserves and Native Fisheries in British Columbia, 1850 to 1927.
Yes.
You have a master's degree in law focusing in legal history.
Yes.
You obtained that from UBC in 1998.
Yes.
And your master's thesis was titled The Legal Capture of British Columbia's Fisheries, a Study of Law and Colonialism.
Yes.
You obtained your law degree in 1993 from the University of Toronto.
Yes.
And you have a Bachelor's of Arts with a major in history from UBC in 1990, correct?
Yes.
You are presently a professor at the University of British Columbia.
Yes.
You've been so since 2001.
Yes.
You've taught courses in property law, fisheries law, First Nations law, among others.
Yes.
And am I correct, you developed the course at UBC for fisheries law?
Yes, I developed a particular iteration of that course, yes.
Okay. You're presently the Associate Dean of Graduate Studies and Research at UBC's Faculty of Law.
Yes, I am.
You've supervised 9 LLM and PhD students, including current candidates.
I believe that's correct, yes.
You, in 1995, you articled with Swinton and Company and were called to the bar of British Columbia.
Yes.
And you've published books and book chapters, articles, and made numerous presentations on topics related to Aboriginal fisheries law in Canada.
Yes, that's correct.
And those are set out in your CV, which we see on the screen.
Yes.
If we could have the CV marked as the next exhibit.
Exhibit number 1134.
Yes, Mr. Commissioner. With that said, and subject to any questions you or any of the other participants have, I'd seek to have Dr. Harris qualified as an expert in the legal history of Aboriginal fisheries in British Columbia.
Very well, thank you.
Dr. Harris, you were asked by the Commission to prepare a paper which provides an overview of significant legal and historical events which have influenced First Nations access to and participation in the Fraser sockeye fishery for a period from initial contact in 1982. Is that right?
Yes.
And there were several components of that in that paper you were asked to specifically address, and I'm going to list 3 of them now and then ask if you agree. 1, the development of historic treaties in British Columbia, including the Douglas Treaties, which contain reference to fisheries, and the implementation of such treaties. 2, the practice of coastal reserve allotments or reserve allotments adjacent to the Fraser River or its tributaries. And 3, the development of Canadian laws, regulations, and jurisprudence directly related to the Fraser sockeye fishery. And you were further asked to describe how these legal and historic events affected the access and participation of First Nations and other groups to the fishery.
That is correct.
Okay. If we could have the paper brought up, Dr. Harris's paper brought up on the screen, please. In response to that request from the Commission, you prepared this paper titled The Recognition and Regulation of Aboriginal Fraser River Sockeye Salmon Fisheries, 1982 to present. Is that right? Or pardon me, to 1982.
That's correct.
And that paper is dated January 12, 2011,
Yes,
and that's the final draft?
it is.
Mr. Commissioner, I just have a brief comment before the paper goes in. This paper is being tendered for its description of the facts. That is, the legal history surrounding such matters as the allocation of reserves, signing of treaties, Aboriginal participation in the fishery, enactment of legislation and regulations, effects of legislation and regulations on Aboriginal participation in the fishery, the evolution of license conditions, etc. It's hoped that the paper and the examination of Dr. Harris by participants will provide a contextual, historical background for the rest of the Aboriginal fishing hearings. This report is not being tendered as a legal opinion. Any legal opinions which may be contained in the paper are not necessarily those of Commission Counsel, and we are not tendering the paper as an opinion on the interpretation or application of domestic law to the facts discussed in the paper. With those comments, I'd ask that this paper become the next exhibit. And after the paper is marked, I understand that Mr. Eisvik has a couple of comments that he'd like you to hear about the paper at this time.
It'll be marked as Exhibit 1135.
Good morning, Mr. Commissioner. Philip Isaac for the ARE and the Fisheries Coalition for the record. We have a problem with this document, and we had some discussions with Commission Counsel over the last few days how to resolve it. And we didn't want to derail the discussions this morning by raising an objection to the discussions. I did have some concern with it being entered as an exhibit, but imprecise language probably led to it this morning. Our concern is the document covers a period to 1982, and if you remember the last time I was here, we had some objection about myself, our organization, entering a 1989 document. So it doesn't really cover the period of the problems that led to the collapse of the Fraser River sockeye fishery. In our view, it's also a one-sided perspective written by an author who has taken one side on what's a really controversial subject. And it's at odds with a number of important Supreme Court of Canada and more recently a BC Court of Appeal decision. So I wouldn't object to it if it was coming in as an expert witness for one of the groups who support this view of history and the law. I do have a problem with it coming in, and I think I need your instructions on it. We don't mind it, all the discussion today. I don't want to derail it, but certainly we'd like to make a written argument precisely on an accelerated timetable at the end of the Aboriginal section, with a view to somehow dealing with what we think is an inappropriate paper submitted by the Commission.
With respect to Mr. Eisvik's comments as to this witness's perspective, that may well be a matter he can fairly pursue in cross-examination. With respect to submissions on the paper, we're of course in your hands as to when you'd like to receive them. To this point, Commission Counsel has taken the position that submissions on matters like this and the weight to be given to a particular document or line of evidence ought to be handled in closing submissions. I understand Mr. Eisvik to be seeking an opportunity to do that on an accelerated schedule. It's obviously in your hands, but today we've certainly taken the position that closing submissions are the appropriate time for those types of submissions.
Mr. Commissioner, if we leave this till closing submissions and weeks of legal argument, this paper will be lost. But it isn't, and given our limited time for cross-examination, I know that I asked for 2 hours, I have 25 minutes. We can't deal properly with the content of the paper in our limited time for cross. And certainly if it's accepted as an exhibit, which it has been, and in the 3 weeks of argument, it'll simply be lost. But it's too important to stand on its own.
Mr. Commissioner, Brenda Gertner for the First Nations Coalition. I just want you to know that I would object to this paper being treated any differently for written submissions than in any other papers or perspectives that we've heard up until now. There's been many, many perspectives that have been provided by many experts through this commission, many of whose perspectives are not necessarily the perspectives shared by any one particular participant, and this one wouldn't and shouldn't have any special treatment. This is a matter for final submissions.
Thank you very much, Mr. Eisvik and Ms. Gartner. Mr. Eisvik, just before you return to your seat, my respectful suggestion is that it would be preferable to make whatever submissions you wish to make about the paper or the evidence that flows today as a result of cross-examinations as part of the final submissions that come from your participant group. I think to me, that would be a preferable way for you to proceed. If for some reason in the weeks that follow this week you have a different view than I have just suggested to you about my preference, I would invite your comment in that regard, or your you could revisit your position. But my preference at the moment would be for you to take the paper and the evidence which flows from it today, and from this week for that matter, and make that, whatever views you have and whatever submissions you have, part of your final submission. But as I say, if for some reason you feel that I ought to hear from you again about this, I certainly wouldn't deny you that opportunity.
Thank you, Mr. Commissioner.
And thank you, Mr. Einsvik.
Mr. Commissioner, that concludes the examination in chief on behalf of the Commission, now that the paper is marked as an exhibit. Next will be Mr. East for the Government of Canada.
Mr. Commissioner, for the record, Mark East for the Government of Canada. I'm here with my co-counsel, Charles Fougere. I have been allocated 25 minutes. With the kindness of Council for British Columbia, I have an extra 5 at my option, and so I won't be any longer than 10:35. Dr. Harris, this is a rich topic, and I have, as I just said, about 30 minutes. So I'm going to focus on one topic in particular, arising from your paper and from the surrounding body of work that you have prepared that fed into this paper. If I have time, and that's essentially the pre-Confederation period. If I have time, I'm going to jump over the intervening 100 and plus years of history and focus on the more recent history, but we'll see how the time goes. The topic I'm interested in discussing with you today, and as I understand it, is your thesis that colonial officials in the pre-Confederation period in Vancouver Island and British Columbia, and I guess Governor Douglas in particular, and at least certain Crown officials in the post-Confederation period, set aside lands for Aboriginal peoples as reserves, not only to secure access and to encourage Aboriginal people into fishing, but also secured and reserved for them the fisheries themselves. And that is both the land from which they fished, but also, at least in some places, reserved for them exclusive rights to fish. Now, have I characterized that properly?
Yes.
And I think in your paper, maybe we'll go to it now, it's the one, Exhibit 1145, you at least infer in your paper that the Douglas Treaty right to fish as formally was intended by Governor Douglas to be defined expansively, and I think that expansively is the term you used. But perhaps I'll take you to the pages in question. That's pages 4 and 5. So the bottom of page 4. And I'm going to go through, what I see is essentially 3 statements from Governor Douglas over different times in correspondence, which you cite as support for this thesis, at least with respect to the pre-Confederation period. So in this paragraph, you refer to Governor Douglas writing to the Hudson's Bay Company that he would strongly recommend, equally as a matter of justice and from regard to the future peace of the colony, that the Indian fisheries, village sites, and fields should be reserved for their benefit and fully secured to them by law. And if we go over to the next page, and in another letter, and when he's describing what he has done with respect to his views of the Douglas treaties, he writes again to the Hudson's Bay Company, I informed the natives that they would not be disturbed in the possession of their village sites and enclosed fields, which are of small extent, and that they were at liberty to hunt over unoccupied lands and to carry on their fisheries with the same freedom as when they were sole occupants of the countries. And then further down, finally, jumping a few years later to, I think it's 1859, down at the bottom of the page. 5 years, in the last sentence, 5 years after concluding the last of the treaties, Douglas informed the Vancouver Island House of Assembly, in similarly expansive terms, that's where the term came in, expansive, that Aboriginal peoples were to be protected in their original right of fishing on the coast and in the bays of the colony. So is it fair to say that based on these three quotes from Governor Douglas's writings, that you infer at least that the right to fish informally, as formally, was intended by Governor Douglas to be broadly construed?
Yes, I think that's a fair characterization.
Okay. And I want to bring up now and your book, Landing Native Fisheries, or excerpts from it. That's Canada's tab 4. Now, Dr. Harris, am I correct in saying your paper is very much built upon and follows upon the theses that you advance in your book, the book that's up on the, well, sorry, this is my list for tomorrow. There it is. So am I correct in suggesting that your paper that you've presented today is very much built upon the book Landing Native Fisheries that you published, I think, in 2008?
Yes, that and other publications.
And other publications. And in fact, I think, would you agree that your paper from pages 4 to 8 are very similar to, I think, pages 21 to 27 of your book? There's definitely a similarity there.
I'm not sure about the exact page numbers, but yes, the material in the paper is drawn primarily from my work in the book and in earlier publications.
Okay. Well, first, maybe I should just mark this as an exhibit. I imagine, Mr. Lund, there's going to be a number of excerpts from this book put in, but just for this purpose, can you put it in as exhibit and perhaps add to it later?
We marked as exhibit 1,136.
Perhaps we can go to page 24, and you're talking here about the Douglas Treaties. Even the terms of the written text are not self-evident. It is clear, however, that fisheries were an important part of the agreement. A fishery, or its plural, fisheries, refers not only to the act of fishing, but also to the places where it occurs. In reserving fisheries, therefore, the Douglas Treaties reserved the right to fish at the places where Native people fished. And that's consistent with what you just said earlier about your thesis that what Governor Douglas was intending to do was not only reserve the right to fish, but also the places to where the fishery was to be undertaken?
Yes.
I want to explore this thesis a bit further. But perhaps maybe we can go to tab 5, Canada's tab 5, page 36. Again, it'd be page 36 of the document. And again, in this book, and first of all, I should mark this. This is your other book, Fish, Law, and Colonialism.
Yes.
So, Mr. Lund, perhaps we could mark this as an exhibit as well.
Exhibit number 1,137.
And right at the very top, talking again about the Douglas Treaties. Just as certain areas of land, village sites, and enclosed fields should be reserved exclusively for natives, so should their fisheries. And again, going further, in a letter to the HBC, Hudson's Bay Company, reporting on the first 9 treaties, Douglas paraphrased the language used in the treaties, expanding somewhat on what he had promised with regard to the fishery. And then he talks about the quote that you have in your paper. So again, you're here making a link in your book to this idea that Governor Douglas intended to reserve exclusively for First Nations their fisheries.
Yes, I think that's correct.
And just following upon that, when you say we're reserving their fisheries exclusively for them, is that suggesting that Governor Douglas intended that these fisheries would be exclusive to others who may want to fish in the same area?
You mean that it would prevent others
prevent others from fishing at the same
areas?
place?
I think what Governor Douglas, and this is the language in the Douglas Treaties, the right to fisheries is formally, and the question here that I guess you're getting at is what does fisheries as formally mean? How are we to interpret what this very brief provision in the Douglas Treaties provides? And so here I've turned to Douglas's other writings, and I think what Douglas is doing is as he says he's doing, securing to Native people their fisheries. Now, fisheries need to be conducted in particular places. A fishery isn't something that can occur in the abstract. It needs to occur in particular locations, and particular locations and fishing is not equally good everywhere. And so to secure or to protect a fishery means, I think, protecting the places that are of particular importance to the catching of fish. And I think that is what Douglas understood he was doing in the treaties. He was securing to Native people their fisheries. Now, does that mean that he thought no one else could participate in the fisheries? No, I don't think so. Douglas fully expected that an incoming settler society would have access to the fisheries. But that access would be in such a way as not to disturb or not to prevent Native access to those prior fisheries. And I think that's what Douglas is trying to do here. He's trying both to secure fisheries for Native people as well as create space for an incoming settler society. I think that's the balance that he's trying to draw in these treaties.
Okay. Well, that's important clarification, and what I would like to do in the time I have remaining is to take you to some other contemporaneous documents, especially from Governor Douglas, and maybe advance perhaps slightly different hypothesis, but maybe not too different from what you just articulated just now. Before I do that, though, I just wanted to note again, and I think there was I just want to reference, just for context, I suppose, the Supreme Court of Canada decision in Nicol, which is at BC's document number 2. And it's at Roman numeral number 28. And Mr. Commissioner, I don't propose to mark the case law, obviously, as an exhibit, but perhaps it can be marked for identification because others may be referring to this document somewhat later today. So it's paragraph 28. And I just want to read this out because I think it articulates what the Supreme Court of Canada has said about the thesis that you've advanced in your paper, and it's this. The historical evidence as to the standard practice of the Crown can be conveniently divided into pre- and post-Confederation periods. This evidence, taken from documents in the public archives, demonstrates that in both periods, there was a clear and specific Crown policy of refusing to grant, in perpetuity, exclusive rights to the fishing grounds. The Crown would, however, grant exclusive licenses or leases over particular areas for a fixed period of time. Obviously, this practice was far from an absolute assignment of a fishery right. I mean, you would agree this is a unanimous, on this point at least, that the Supreme Court of Canada was unanimous.
Yes, I would agree that the Supreme Court was unanimous. I would not agree with this opinion, however.
You don't agree with this opinion or this view of this decision of the Supreme Court of Canada?
I don't agree with this interpretation of Crown policy.
Okay. Now, and maybe we'll go further on that, but I guess the point here, and I guess perhaps this is where this differs from your viewpoint, is that there's an argument here of continuity in the Supreme Court of Canada between the pre- and post-Confederation periods, that there's a continuous Crown policy throughout this period. And is that what you disagree with?
Yes. I think what the Supreme Court is reflecting is the continuity from the mid to late 19th century of the perspective of the Department of Fisheries, and only that. That there were other perspectives within the Crown, and certainly Governor Douglas's perspective, I would argue, was a different one. The Department of Indian Affairs had a different perspective. There wasn't a unified Crown policy. There were many competing, or a number of competing, Crown policies towards the Aboriginal fishery, of which the Department of Fisheries was one, and this interpretation reflects the Department of Fisheries' position, but I don't think one can say, as Justice Corey says later in the call, that it was always the Crown's policy and intent.
Okay. And maybe a bit further on this, perhaps we can go back to your book. This is the one at tab 4, Landing Native Fisheries.
Mr. Commissioner, I'm just going to rise for a second to suggest I don't think it's appropriate to mark cases as exhibits, but perhaps for the sake of the record, it might be appropriate to mark the last case for identification.
That's what I intended. Thanks.
It'll be marked as for identification as GG, double G.
Tab 4, Landed Native Fisheries book at page 194 in the text. I think it's the third from the last page in the ringtail. And here, as you can see, you begin to discuss the Supreme Court of Canada decision in Nicol and Lewis in particular. And you say the Supreme Court's conclusions about the authority of the reserve commissioners and the intent of the Crown are more difficult to sustain. And just for the record, these cases were about questions around reserve allocations in the post-Confederation period. Is that right?
Yes.
And in this paragraph, you essentially articulated what your answer was just now about how it was the view of the Department of Fisheries that that informed the decision of the Supreme Court of Canada in Nicol and Lewis.
That's correct.
And over on the next page, perhaps we can go, and I'll just... You make the linkage in the first full paragraph to the Douglas Treaties. And you say, perhaps in the first line, you say, although fisheries articulated its vision of limited native fishing privileges most forcefully, it was never the only view, even in the late 19th century. You discuss the perspective of native peoples in the next line. And then in the third line, which is what interests me, the fisheries clause in the Douglas Treaties, the right to fisheries as formerly, provides some evidence that colonial officials in British Columbia also understood that native fishing rights emanated from past practice, not the Crown, and that those rights were to be broadly construed. So again, that's consistent with the evidence you've given thus far about what Governor Douglas viewed the extent of the right to fish as formerly.
Yes, and I think this is the really important point, that the Department of Fisheries understood the fishing rights of Native people as being granted by the Crown and only granted by the Crown, and then hence its position that the public right to fish prevented the Crown from allocating exclusive fisheries. I think what I'm saying here is that within that frame, the position may be correct, that is that the public right to fish limited exclusive allocations of fisheries, but that the frame is wrong, that what was happening here was not the granting of fishing rights to Native people, but rather the recognition of existing rights, or at least the recognition of the existing patterns of use and management of the fishery. Right? And if one understands the frame as the recognition of rights, then the public right to fish doesn't act as a limit on the Crown's prerogative.
Okay. I want then to take you to some other correspondence in the time I have remaining from Governor Douglas, and perhaps I'm going to advance a different hypothesis. By doing that, or at least a variation of this hypothesis, if we go to Canada's tab 53, please. Now, this is a letter from Douglas to the Colonial Secretary, the Duke of Newcastle. It's not referred to in your paper, but I believe you refer to it in your book. And it's that. Perhaps we can go to, so this is a letter from, dated 1860, and I believe it's also referred to in the Nicol case. Do you recognize this letter?
I can't say that I do immediately, but...
Well, I'll take you to perhaps in your book where it is. But first of all, I want to take you to this document. I'll mark it as an exhibit, perhaps. This is a letter from the Governor Douglas to the Duke of Newcastle.
The exhibit number 1138.
And if we can go to page 4 and 5 and ringtail on this document, please. Start with page 4. And I think when I read this out, you probably recognize it. I think this is an off-cited clause, where it says, I also explained. So this is, as I understand it, is a meeting that Governor Douglas, recounting a meeting he had with Aboriginal people in the BC interior, at a meeting in a town of, what is now the town of Lillooet. And he says this, I also explained to them that the magistrates had instructions to stake out and reserve for their use and benefit all their occupied village sites and cultivated fields, and as much lands in the vicinity of each as they could till, or was required for their support, and that they might fully exercise and enjoy the rights of fishing the lakes and rivers, and of hunting over all unoccupied Crown lands in the colony. Do you recognize this quote now?
Yes.
And actually, it's back in your book at tab 4, Canada's tab 4, at pages 25. Because you had something very interesting, stated something very interesting about this passage. It's page 25 in the text. This is Landing Native Fishery Canada's tab 4. You're referring to the quote, and in the very last line, and over the next page, although clearly echoing the language in the treaties, these are the Douglas treaties, the characterization of the rights to hunt and fish was somewhat narrower. The right to hunt extended only to unoccupied Crown lands, without any reference to prior rights or to fisheries as formerly. The promise that they might freely exercise and enjoy the rights of fishing was little more than what Douglas would have told a non-native audience. And then you say, the end of the treaties marked the end of Douglas's formal recognition of native title, and perhaps by 1860, he was being more circumspect in his recognition of rights to hunt and fish as well. I'm going to stop here, and I'm going to suggest that just up to your last sentence, I would suggest that your interpretation of what Governor Douglas was saying here is correct. Governor Douglas intended that people, all Crown subjects, would enjoy the same rights to hunt and fish in the territory. And that's perhaps a slightly different hypothesis than the one that you're suggesting in your paper and in your books. Would you agree with that?
No. I think incoming settlers had rights to the fisheries based on the public right to fish. They did not have rights as recognized in the Douglas treaties to fisheries as formerly. Now, exactly what Douglas was meaning by fisheries as formerly is what I'm trying to work out. But I think it's wrong to say that those with treaty rights have the same rights as everybody else. I think that's incorrect. And I also think that, well, it's important to get at what Douglas was trying to do with the treaties. We need to remember that treaties are a two-sided agreement, and that what Douglas was trying to understand and do with the treaties is only one side. And there's this whole other equation, how Native people understood what they were doing in coming to these agreements. And it's clear that fisheries were crucially important. It's also clear that fisheries were the central source of wealth, of economic activity, pivotal markers in a cultural and broader social makeup. And so, well, yes, I think Douglas clearly thought he was protecting Aboriginal fisheries and securing them broadly, and securing them in a different way than non-natives would have access to the fishery. There's a very real question of what Native people thought they were doing as well in coming to these agreements.
Yeah. And I don't disagree at all with your last statement there. I think you would agree that as a matter of law, when interpreting treaties, you have to look at the tension of both sides, as you just said. And so it's crucial for us to have a good understanding of what Governor Douglas intended when entering into these agreements. Would you agree?
Yes.
In interpreting these treaties. So I want to go now to a couple of other documents. One is tab 8 of Canada's documents, and this is a letter that you have referred to in your paper. And this is the one where you refer to the fact, or Douglas refers to the fact that Native tribes are to be protected in their original right of fishing on the coast and in the bays of the colonies. I'd like to go a little further, though. And he continues to say, I'm just trying to read this. Could you blow it up a little bit, please, Angela? At the very bottom. And of hunting over all unoccupied Crown lands, and they were also to be secured in the enjoyment of their village sites and cultivated fields. Next page. These rights they have since enjoyed in full, this is 1859 now, and the reserves of land covering the village sites and cultivated fields have all been distinctly marked on the maps and surveys of the colony, and the faith of the government is pledged in that their occupation shall not be disturbed. For that reason, the government will not cause them to be removed, because it is bound by the faith of a solemn engagement to protect them in the enjoyment of those agrarian rights. And I find it interesting here that in this document, there's no discussion of anything other than their lands. There's no reference to fisheries and protecting them in their occupation of fisheries in this document. Would you agree?
No, I think the very first sentence says they would be protected in their original right of fishing. In the previous page.
But there's no reference here to their reservations of fishing sites or fishing grounds or fishing stations in this document, specifically.
They were to be protected in their original right of fishing on the coast and in the bays and colonies. I mean, there's even a specific geographical location being indicated. So, no, I think there's quite clearly reference to fishing. The original right of fishing. Now, right, that phrase, right, what's Douglas meaning there?
Yeah.
The original right of fishing. Well, originally Native people were the only fishers. They had exclusive fisheries. Does he mean that they were to have exclusive fishing rights? Well, perhaps in particular locations, all right, in the bays of the colony. Right? So I think there is a clear intent here on Douglas's part to secure to Native people their fisheries, which means to secure a fishery without securing the locations is meaningless. Right?
Then I'm going to juxtapose that. Then I see your point there, and I'm going to juxtapose that. And in my time remaining, I'm just going to bring up maybe a couple more documents. One you refer to in your paper, and that's the prospectus for settlers. And that, I'll go, and rather than go to the original document, in the interest of time, I'll go back to the paper at tab 4. Yes, thank you. I should mark this last document as an exhibit.
1,139.
So your paper at page 7, and you refer to the prospectus that was provided by Hudson's Bay Company. And I'll just read it out. The line that interests me is this. Every freeholder will enjoy the right of fishing all sorts of fish in the seas, bays, and inlets of or surrounding the said island. And if I understand your interpretation correctly, that is a reference to the public right of fish in tidal waters.
Yes, I think the holders of land were being granted the same right that the public enjoy at large, which is of the public right to fish.
And isn't it striking that it's very similar to language used later in 1859 when Governor Douglas said, and again it's quoted in your paper, Aboriginal peoples were to be protected in their original right of fishing on the coast and in the bays of the colony. And I guess my question is, how is it that both the freeholders, the settlers, and Aboriginal peoples are being granted essentially the same right over the bays and inlets and the coast of the colonies?
Well, I think they're not, because I don't think both rights are being granted. Right? So the public right to fish is a limit on the Crown's prerogative to allocate exclusive fisheries. It's a common law doctrine which says that the Crown does not have within its prerogative the right to grant exclusive fisheries. Now, Aboriginal people had pre-existing rights to fisheries, rights that preceded the British assertion of sovereignty, that preceded the introduction of the common law to this territory. And so to characterize those rights as being rights that were being granted by the Crown, I think is erroneous. I think what's happening is that Douglas is recognizing prior rights to the fisheries. And in that context, the public right to fish doesn't act as a limit on what the Crown can do. The Crown isn't granting these fisheries to Aboriginal people. It's recognizing the prior fact of these fisheries. Fisheries that preceded the assertion of sovereignty. Fisheries that preceded the application of the public right to fish. Just as in England, fisheries that preceded the Magna Carta were not subject to the public right to fish. So just as in Eastern Canada, fisheries that had been granted, exclusive fisheries that had been granted by the French Crown prior to the British assertion of sovereignty were not subject to the public right to fish. So Aboriginal fisheries, exclusive Aboriginal fisheries that preceded the British assertion of sovereignty are not subject to the public right to fish. So the public right to fish acts as a limit on what the Crown can do. It says you can't grant exclusive fisheries. I think that's not what's happening in the Aboriginal fishery. What's happening is a recognition of prior fisheries.
I'm nearing the end of my time, and I had all sorts of documents that I wanted to bring to your attention that would advance perhaps this thesis, which I'm going to put to you, and then I'll leave it. And that is, what was happening in the 1850s, this being a colony of Victorian England, was that Governor Douglas was primarily focusing on opening up the colony for settlement and to build trading relationships with the Aboriginal people and others. To the extent that he was negotiating treaties with Aboriginal people at that time, he was encouraging them in their pursuits of fishing. But that the intention of Governor Douglas at this time, and of colonial officials and post-Confederation officials subsequently, was not to grant landed property rights to any Crown subject in the fishery, whether that's inland or tidal. Would you agree that that's a reasonable, or at least an arguable hypothesis?
That Douglas was not intending to grant
Exclusive fisheries to any Crown subject in 1849 until his end of his tenure as a governor of the colony.
I can recall no instance where he did grant an exclusive fishery to an immigrant.
Well, I'm telling you, a Crown subject in the eyes of Governor Douglas would include Aboriginal people.
Well, so here one needs to bear in mind Douglas's first statement before the treaties were signed, which is that native village sites and fisheries should be fully secured to them in law. Now, this isn't a statement about a general public right to fish, but rather a specific statement about Aboriginal fisheries being fully secured to them in law. I think that Douglas was intending to treat Aboriginal fisheries differently. I think this is the reason that, one of the reasons anyway, why the right to fisheries as formerly suggesting prior practice is in the Douglas treaties. I think also that Douglas was operating in a context of abundance, and so that it was less important to clearly define the boundaries between Aboriginal fisheries and non-Aboriginal fisheries. But I don't think that means Douglas wasn't intending to secure Aboriginal fisheries. I think he says quite clearly that he was, and I think the Douglas treaties indicate quite clearly that he did.
I'm just going to leave it with this because I'm out of time. Would you agree that this is a live and controversial area of both law and in history, and that to properly engage in a discussion of the subject matter, we would need a full panoply of evidence, the analysis of expert witnesses like yourself, and a full opportunity to make submissions in a court of law or to a commissioner inquiry to fully get a full analysis of these issues? Would you agree with that?
I would agree that the right to fisheries as formally has not been definitively interpreted in a Canadian court, and that
Okay. Thank you. Those are my questions, Mr. Commissioner.
Commissioner Boris Tyzik for the province of British Columbia. Good morning, Dr. Harris.
good morning.
I just want to follow on that point. You said, when asked whether this is a controversial area and whether there would be a need for, in effect, a full trial, a full hearing of this, I didn't get you said it hadn't been defined. So do you agree it's a controversial area? Are there differing points of view from yours?
I think this is an unresolved area, and yes, I think there are differing perspectives.
Okay. And I'd just like to sort of get into that, because in your paper, you've got a specific area, and Mr. Lunn, if we could turn to pages, I think it starts on page 25 of the paper by Dr. Harris, goes on. You talk, the heading there is Indian Reserves and Fisheries, and you go on for about 4 or 5 pages on this. And the thing that I note is that in those 4 or 5 pages, there are no references to either Nikel or Lewis. The only reference in Lewis to your paper is footnote 91 in the conclusion. Why is that?
Because this was not intended as a analysis of contemporary Canadian case law, but rather a historical analysis of the Aboriginal regulation or at least of the regulation of the Aboriginal fisheries.
Both those cases, in this description, and albeit it is very brief and you were limited in what you could do in here, you do make references to your book, but you make references to what some comments of what the Indian Reserve Commissioner Sproat and O'Reilly did. And their approach, their mandate, were matters that were specifically dealt with by the Supreme Court of Canada in Nikel and Lewis, were they not?
Yes.
They were. Mr. Lund, just to get housekeeping matters out of the way, I think BC document number 1 is the Lewis case. Could we get that marked for identification, please?
Be marked for identification HH, double H.
I'm going to go through some of the cases. Mr. Commissioner, there are references to documents here, but given the limited amount of time we have, I would note that a fair number of the ones referred to by the Supreme Canada are in Canada's document list, but we just don't have time to go through it. So what I heard you say is that, now if we go to NICAL, which is exhibit GG, in answer to my friend's question, you believe that the at paragraph 28, that contrary to what the Supreme Court of Canada says, your view is that was the policy of the Department of Marine Fisheries and not necessarily the government.
Yes, I think what the Supreme Court has done in these two cases is take the position, the particular perspective of the Department of Fisheries as the statement of Crown policy, and has not recognized the competing interpretations, the contemporary competing interpretations, meaning the different ways in which the different branches of the Crown understood fisheries policy in the late 19th century. And here I think it's important to, right now we're accustomed to thinking of a unified Crown, at least unified federally and unified provincially. There are many examples in the historical record of Department of Fisheries and Department of Indian Affairs being at loggerheads, and quite publicly at loggerheads, appearing in trials on opposite sides of issues. It's not something that happens now, it's something that was common in the late 19th century. The Crown was not a unified entity. It was
but the court found that they were.
And I think that this is an erroneous or a misrepresentation of Crown policy. It's an accurate reflection of what the Department of Fisheries understood the policy to be, but it was one perspective that was current in the late 19th century.
It was one perspective that was current. And let's just go to some parts of that, because if we go to paragraph 37, I'm having to remember my Roman numerals, and on, we start to talk about the mandate of the Reserve Commissioners in NICAL. And in your paper, you refer to specifically on page 29, and I'm sorry, Mr. Lunn, I'm going back and forth. And about halfway down that large paragraph, we say here, at the enormously productive Aboriginal salmon fisheries above and below the confluence of the Bridge and Fraser rivers. And then it goes on, just north of Lillooet, O'Reilly allotted not only reserve land, but also the exclusive right of fishing along a 70-kilometer stretch of the Fraser River. The mandate of the Reserve Commissioners is a matter, and you quote there, I think, something from one of O'Reilly's notes, but there is no discussion of what the Supreme Court of Canada set out in terms of what the mandate of the Reserve Commissioners were, including Sproat and O'Reilly.
That's correct.
That's correct. Because what they say, starting at paragraph 37, And then going on under the heading, the mandate of the Reserve Commissioners is, accordingly, when Reserve Commissioners were appointed a few months later with a mandate to allocate reserves in BC, they were certainly not either specifically authorized or by inference empowered to grant exclusive rights in the fishery.
So I think this is a limited view of the instructions that the Reserve Commissioners received. If I may just point you to page 41 of my report, which is the map of what Peter O'Reilly was doing when in 1881 he was traveling through the Middle Fraser.
That's the case, yes, and that is your view. But if you go on to paragraphs 38, and there, we have some quotes here from that the Supreme Court of Canada refers to. The first in paragraph 38 is, in a letter from D.C. Scott, Deputy Superintendent General of Indian Affairs, to D.H. McDowell, Commissioner, Royal Commission on Indian Affairs for the Province of British Columbia, dated May 2, 1916, it was stated, those two paragraphs, I don't think that the former commissioners could grant special privileges as distinct from fishing stations and reserve. The department has no record of confirmation of such by the Department of Marine and Fisheries. And later on he says, I cannot find that Mr. O'Reilly had power to grant any fishing privileges whatever. And they go on to the next quote from Robert Sedgwick, who is the Deputy Minister of Justice, and he goes on to say, the Indian Reserve Commission appears to have the power to mark out reserves, but does not appear that the Governor and Council or any other authority ever gave or purported to give him authority to deal with the right of fishery. And then they miss out some, and they say, I therefore state that the Indian Reserve Commissioner has no power to set apart for the exclusive use of the Indians any waters of British Columbia. And then there's a quote that comes from J.D. McLean for the Department of Indian Affairs, which I think may get closer to what your thesis might be, where they say, as to the fishing rights in British Columbia, it should be stated that under the arrangement with the government of the province in 1876, by which reserves were to be set aside for the Indians, no special mention was made of fishing privileges, but the Reserve Commissioner from time to time allowed in Indians certain fisheries, and the Department of Marine Fisheries had been advised of these and asked to confirm them, but so far the correspondent shows the department has not confirmed them and has objected to exclusive fishing privileges being granted to the Indians.
So I would agree that the Department of Fisheries certainly thought that it had the jurisdiction to grant exclusive fisheries and that it was not prepared to grant exclusive fisheries to Native people. I would also agree that the Department of Indian Affairs eventually came around to this position and acquiesced in the Department of Fisheries position. But would it be possible to bring up the map that I have in my report on page 41, just to provide a little bit of context about what was going on here? So this is Peter O'Reilly in 1881, and this is his first work in the field as an Indian Reserve Commissioner. He's appointed, and he heads to the Middle Fraser, just north of Lillooet, with a mandate to allot reserves. And this is what he does. He allots these reserves, shown as shaded, on the banks either side of the Fraser River, and then he also allots exclusive fishing rights. And so up at the top of the map to the high bar on both sides of the river, the exclusive fishing right, to the Clinton, a right of exclusive fishing that extends beyond their reserve boundary, same to the Pavilion, that long stretch of river, exclusive fishing rights on both sides of the Fraser. Now, Peter O'Reilly was not known for his sympathy towards Native people. He was a very effective, efficient colonial servant who did exactly what and no more than what he thought he had been instructed. This is clear in the historical record and over the 20 years that Peter O'Reilly is acting as Indian Reserve Commissioner. Now, when word of these exclusive fishing grants comes back to the Department of Fisheries, the Department of Fisheries demands an explanation. It asks, where has the authority come from to allocate these exclusive fisheries? And the Prime Minister, John A. Macdonald, who was also then Superintendent of Indian Affairs, in a letter from December 20th, 1881, says, I instructed him right, that it was proper and expedient, I think are his words, it was proper and expedient for him to set aside their fishing grounds. And that's what O'Reilly understood his instructions to be. And that's what he's doing here. And that's also what he does when he goes later in 1881 up to the Nass and sets aside reserves and exclusive fisheries for the Nisga'a. And so I think what O'Reilly's work reflects, and it's what the earlier Reserve Commission, Gilbert Malcolm Sproat, was trying to do, is to recognize that the questions of land and fish were inseparable, that land grants here were meaningless unless there was secure access to the fishery. And he understood his instructions as including the setting aside of exclusive native fisheries, and that's what he's doing. Now, the Department of Fisheries reacts, yes. Yes, the Department of Indian Affairs, much later, 1890, and by 1900 certainly, eventually acquiesces in this position, but it's not the only position that's out there. And of course, all of this is in the frame of understanding what the Reserve Commissioner is doing is as granting fishing rights. Right? Department of Fisheries is objecting because it says the Reserve Commissioner has no authority to grant fishing rights. Well, I think that's a misconstrual of what's happening here. The Reserve Commissioner is allotting reserves, yes, he's allotting exclusive fishing rights, yes, but those are, what's happening here is a recognition of the prior fact of Aboriginal occupation of this territory and use and management of the fishery. That this is not the granting, this is the important difference between what's happening with the Crown and an immigrant society and what's happening with the Crown and Aboriginal peoples. These aren't grants, these are recognitions of centuries, probably millennia of use, of pre-existing rights. And as a result, fisheries' objection to these grants is premised on the fact that they conflicted with or were not consistent with the public right to fish. But
which of course is your view, and I'm sorry, I don't mean to cut you off.
But that's, the Crown isn't granting, or at least one conception, one understanding of what's happening here is that the Crown is granting rights. I don't think that's the best conception. I think the best conception is of the recognition of rights. But even if one understands this as a grant of a right, fisheries opposition was premised on the public right to fish. The public right to fish only applies in tidal waters. These waters are clearly not tidal, and so the legal foundation for the Department of Fisheries objection is based on a misunderstanding, a misapplication of the public right to fish.
But that now, and you mentioned that in your paper, but as I understand Canadian jurisprudence, up to 1921, prior to the Privy Council decision, up to the Supreme Court of Canada, they accepted the fact that the public right of fish included navigable non-tidal waters. Is that not the case?
That's not the case. No, that's not the case. So.
And okay, but and yet you have others, and Mr. Wright in his paper, and I believe it's Area E's document number 6, Mr. Lunn, and it starts with a paragraph modeled after, and he says this: while the Judicial Committee of the Privy Council would later in 1921 confine its amendments to the fisheries of tidal waters or to fisheries so accessible from the seas to make them natural adjuncts to these fisheries, pre-Confederation officials neither intended nor considered it to be so restricted. Like the common law public right, they believed it applied to all fisheries in navigable waters of the province. So you disagree with that point of view?
No.
Thank you.
But this is of the province in reference to Ontario. So there is a line of cases in the mid-19th century which suggests when Ontario was Canada West, so not yet part of the Canadian Confederation, there is a line of cases which suggest that the public right to fish applies in navigable waters, understood as navigable waters. So in England, the public right to fish applied to navigable waters, understood in law to mean tidal waters. Now the question in North America was, does the public right to fish apply in navigable waters, understood in law to mean navigable waters? In other words, does it apply to the Great Lakes? And there are a line of cases from Canada West which suggest that the public right to fish did apply in navigable, non-tidal waters like the Great Lakes. That is not the law in British Columbia, and this is revealed in the 1880 case of the Queen and Robertson. It's a New Brunswick case. The judge in that case clearly knows of these Ontario or Canada West decisions, has referred to them in an earlier case of his. In that case involving New Brunswick, he turns not to the body of law that's being developed in Canada West, but rather to England, and says that the body of law that applies in New Brunswick in 1880 is the body of law from England. So the public right to fish understood as applying to navigable waters, meaning tidal waters. That is the body of law that then is carried through in the late 1890s and the early 20th century that applies to British Columbia.
That's your view.
And I have set it out at length in Chapter 4, I think, in Landing Native Fisheries.
Okay. Could we get the right paper marked as an exhibit, please?
Marked as exhibit number 1140.
And I just have...
Mr. Commissioner, I rise to perhaps my friend for the commission ought to be rising. I understood this witness to be tendered not to give a legal opinion, and a statement such as that is not the law in British Columbia is far outside the scope of the expertise that this witness was accepted as holding.
Yes, Mr. Commissioner, the witness was qualified as an expert in the legal history of Aboriginal fisheries in British Columbia, and I think we ought to make every attempt to keep the evidence focused on the historical context and the factual underpinning that is set out largely in the paper and the context surrounding it.
I see my time. I just have 2 points. One is just on the general question of the instructions given to the reserve commissioners. If we could go to the Lewis case. And again, here, and this is another unanimous decision of the court. At paragraph 34, they again make the statement and rely on NICAL that the historical evidence shows the authority and mandate of Indian Reserve Commissioners as representatives of the Crown was limited to allocation of land to the Indians, but they could only recommend an allocation of an exclusive fishery that would then have to be approved by the Department of Marine and Fisheries. And they refer to NICAL in those paragraphs 38 to 54. Then if we just turn to paragraph 41 of that case, it says, all Indian Reserve Commissioners receive the following general instructions in relation to the point of reserve location. They talk, and again here, granted it's about reserve location, but what they focus here on, if you'll see, is they reference to fishing stations throughout. And I guess I just want to finish on this. Dr. Harris, it's clear. This is a controversial area, both in the law and in the history, is it not?
This is a very controversial area. And could I respond to your observation about paragraph 38?
Sure. Please do.
So paragraph 38 suggests that the reserve commissioner could only recommend the fisheries to be reserved. Well, in fact, the commissioner's mandate was only to recommend the land that could be set aside, as well as recommend the fisheries that were to be set aside. It was for the provincial and the federal governments later to confirm those recommendations. So in fact, this statement about the reserve commissioner's jurisdiction in the fisheries is really no different from their jurisdiction over land. That their role was to recommend it. And in this, the Department of Indian Affairs conceded that point. The reserve commissioners had no jurisdiction to do anything other than recommend, but the Department of Indian Affairs fully expected that the Department of Fisheries would act on these recommendations, just as it expected the lands departments of the province and the federal government to act on the recommendations of the reserve allotments regarding land.
Okay, so when we go to paragraph 29 of your paper, and that line that I referred to you in the middle of the paragraph where it says O'Reilly allotted not only reserve land but also the exclusive right of fishing along a 70-kilometer stretch. In effect, really what he did was make recommendations as to both. He did not allot anything, given what you've just said.
Yes.
Thank you.
Yes.
Those are my questions. Thank you very much for answering my questions.
Commissioner, Mr. Eidsvik will be next.
Good morning, Mr. Commissioner. Philip Eidsvik for Area E in the BC Fisheries Survival Coalition. And good morning, Dr. Harris.
Good morning.
In your introduction, you make a couple of points of interest to me. And the first one is that no species was more important in the territory that became British Columbia than the Fraser River sockeye salmon. And if I could go to tab 25, Mr. Lund.
Out of your list of documents?
Yeah, out of our list of documents, please. Now, this is a letter from the Quagga chief to the Inspector of Fisheries dated 1912. And you go partway down that first page, and perhaps I can read it, and if I get it wrong, you can correct me. We've been very anxious about our fish, the dog salmon. We heard that the cannery here is going to fish these fish, and we have asked the Indian agent or Indian department to help with this matter of the dog salmon, which is the staple food of all the Indians around here. So dog salmon's pretty darn important to the Quag youth.
Yes.
Perhaps I can go to tab 26, Mr. Lund. Now, Wayne Suttles is a pretty well-known, well-respected commentator on Aboriginal issues in
Yes.
British Columbia.
More than a commentator, one of the most well-respected anthropologists.
Yes. Perhaps you can go to the second page, Mr. Lund. And I think his comment here is interesting. He's about the second paragraph down on the page. He says it should also be noted that, there we go, at the bottom of the screen, that paragraph, Mr. Lund, should also be noted that not all species of salmon, perhaps not even all populations, keep equally well. My Salish informants say that fatter fish last longer and the sockeye and dog salmon are their favorites. Other species may not last long through the winter months. And there's an asterisk there, if we could go down to the footnote, Mr. Lund. And as you'd expect from Mr. Suttles, who corrects his errors, he says, I was quite wrong about this. As Curtis reported for the Quackudal, it is leaner fish that preserve longer. Sockeye are relished for their fat, but do not last as long. Dog salmon are lean and last longer. So another comment that dog salmon are an important species, not sockeye. And perhaps if I could go to tab 29, Mr. Lund. And this is testimony before the Dominion of Canada.
Rise, I have a couple of comments. The first is just procedural. I'm not sure if Mr. Eidsvik wishes to mark the exhibits
Yes,
he's referring to.
Thank you, Mr.
The second is the last couple of exhibits Mr. Eidsvik has read from but has not posed a question to the witness. This is an opportunity to ask questions, not to
I
read
thought
from
I had
documents
posed
and
a
make-
question when I asked him if he thought that sockeye and dog salmon were important. But I'll continue on. I wonder if I could have tab...
Perhaps before Mr. Eidsvik continues on, the witness could be given an opportunity to answer the last question, then if one was in fact put.
Perhaps I can get tab 25 marked as an exhibit first.
Exhibit number 1141.
And tab 26 marked as an exhibit, please.
1142.
Now, did you have a comment on that, Dr. Harris? On Dr. Suttle's comments about that he was wrong about sockeye being as important as dogs?
I don't have a comment about that.
Perhaps we can go to tab 29. And this is a record of proceedings of the BC Salmon Fisheries Commission in 1892. And if we could go into the first part, Mr. Lund, where the transcript is. And you can see at the bottom there, it highlights, refers to Charlie Chaplin, who's the chief of the Musqueam Indian Band. And then perhaps we can go to page 131 at the very bottom of the page. And this is a question to the Musqueam chief, and he's asked, because they're going through an interpreter, ask him whether as a tribe they consider the spring salmon or the sockeye for their best known use. Excuse my reading. And the answer is they would rather have spring salmon for their food than sockeye. Some Indians would not look at the sockeye to eat. They don't like them. Do you believe that the Musqueam chief knew what he was talking about at that time?
I'm sorry, but I don't really know the context of either the question or the answer, and nor do I have a particular expertise to comment on this.
Well, I'm just, in your paper you said that no species was more important than sockeye in the introduction to your paper.
And I would stand by that, yes.
This Musqueam chief may disagree, at least in the case of certain people.
This testimony appears to indicate that there were certainly other species of salmon that were important.
Thank you. Now, I want to go to page 4 of your paper where you talk about the Douglas Treaties, and a couple of quick questions. Between 1850 and 1854, when the Douglas Treaties were signed, Douglas was the governor of Vancouver Island, not the mainland, correct?
That's correct. He was actually the chief trader of the Hudson's Bay Company, and then later chief trader and governor of the proprietary colony of Vancouver Island.
No jurisdiction over the Fraser River. Became governor of British Columbia in 1858, some 8 years after the Douglas Treaties. Is that correct?
I beg your pardon, who?
He became governor of British Columbia?
Yes.
So at the time he signed the Douglas Treaties, he had no jurisdiction over the Fraser River.
He was the chief trader and the governor of the colony of Vancouver Island.
Right.
That's correct.
Which does not include British Columbia, the mainland.
Which does not include the mainland.
Thank you. At page 5 of your paper, you refer to Douglas when he writes about his understanding of what transpired. And I think this is a helpful comment, and I'm glad you included it. Partway down through the page, he says, to carry on their fisheries with the same freedom as when they were sole occupants of the country. And you'd agree with me that the fishery today looks a lot different than when the Douglas Treaty signatories were the sole occupants of the country.
Yes.
And you could interpret fishing as formally, according to Governor Douglas here, as when they were the sole occupants of the country.
Yes.
No Hudson's Bay Company then?
I think, as I said earlier, what Douglas is trying to do is to secure to Aboriginal people their fishing rights. It's a recognition of the importance of the fisheries to Aboriginal cultures and economies in the mid-19th century, and that's reflected in the right to fisheries as formerly in the Douglas Treaties.
Thank you. On the next page, page 6, at the end of the top first paragraph, you say the treaties were concluded in the context of well-established ongoing commercial activity involving the HBC and Aboriginal peoples. Now, the Supreme Court of Canada dealt with the contract and activities between Aboriginal peoples on the Fraser River and the Hudson's Bay Company in a case called Vanderpeet, did they not?
Certainly the question of Aboriginal rights to commercial fisheries was the subject of the court's attention in Vanderpeet.
And the court concluded that the HBC trade with the Stow did not give rise to an Aboriginal right to sell or even to trade and barter. Is that correct?
The Supreme Court determined that the First Nation had to establish that the activity was integral to a distinctive pre-contact culture.
And they concluded that trade with the Hudson's Bay Company was not integral.
Mr. Commissioner, it appears we're straying again into asking the witness for a legal opinion.
I'll move on, Your Honor. Commissioner, thank you. If we could go to tab 24, Mr. Lund, that would be helpful.
Mr. Isaac, at tab 29, I don't know whether or not that's required.
I'm sorry. Thank you again, Commissioner. Could I make tab 29 an exhibit as well?
So that'll be marked as exhibit 1143.
I apologize. Which tab are you at now?
I'm at tab 24.
Of your finding?
Pardon?
Of your document?
Of my documents, of the Area E documents. Tab 24. Now, this is an expert opinion by Wayne Suttles to the Musqueam Band, and perhaps I could go to page 2 of that document. And in the second paragraph, he says, some of the features of the exchange system have been indicated above. Food was simply shared within the family. And skipping down, however, it is important to note this was not a market system. There was no all-purpose money. It is not possible to take a surplus of food and simply peddle it. Do you agree with Dr. Suttle's interpretation, referring to the Musqueam pre-European contact?
I'm not sure if he's been qualified as an anthropologist in this hearing, Mr. Commissioner. It sounds like that's the nature of the question, or at least that's how I've heard it. And so if he's asking for an anthropological expertise, that should perhaps be clarified. It doesn't look like legal history.
I'm simply asking, Dr. Harris commented on the qualifications of Dr. Suttles earlier on, and this is an opinion of Dr. Suttles. Do you believe that Dr. Suttles was in error when he said this, perhaps?
Well, so reading the paragraph as a whole, some features of the exchange system have been indicated above. Food was simply shared around within the families within a house, and the households within a village engaged in reciprocity. Families in different villages through ties of marriage and kinship engaged in exchanges of food and wealth and exchange of access to each other's resources. I think that's all.
But no
I would not disagree with any of that.
Yeah, no market system that we have today at that time. No money.
That's correct.
And it is an interesting point. If we're talking sockeye, and the sockeye hit the Fraser River, the Musqueam actually couldn't sell it to the Stolo because they had sockeye, right?
They could certainly have traded with whomever they wished.
Well, would they have traded sockeye with the Stolo? I mean, the Stolo obviously had sockeye.
So it seems unlikely that they would have, but it's quite conceivable that they might have.
Okay, thank you. I think we'll move on to the public right to fish, Mr. Commissioner. At tab 1, Mr. Lund, would be helpful. Now, the tab 1 of our documents again, and we're going to skip into page. These are royal instructions to British colonial governors from 1670 to 776. And Mr. Commissioner, I regret to say that with Mr. Suttles, I did not make that an exhibit, and I should have. Thank you.
Which one is that again?
The-
Tab 24?
Yep.
Will be marked as 1,144.
And if I could make this an exhibit right straight off so I don't forget again, Mr. Commissioner.
Tab 1 will be 1,145.
Now, if we could go to Mr. Lund, page 691 of this document. Now, these are instructions to British colonial governors in parts of the United States and Canada. And if we're at 956, this is the Placentia garrison. Do you know where Placentia is, Mr. Harris? Dr. Harris?
In Newfoundland?
That's correct. And these are the instructions to the governors there, and they say, you shall strictly enjoin both the present and future garrison of Placentia and all his majesty's officers and soldiers and other persons whatsoever belonging thereto, not to concern themselves in the fishery there, not to interrupt the fishermen in the curing of their fish, and not to take up for themselves any beaches, stages, or cook rooms upon any pretense whatsoever, upon pain of his majesty's highest displeasure. Probably when you get a order like that from the king or queen back that time, her majesty's highest displeasure was pretty serious. You would take that very serious if you were governor.
I would presume so, although this is a very difficult document for me to comment on. I don't know the author, I don't know the date. It's from a different coast in a different era, so I'm not, I can agree that upon pain of His Majesty's highest displeasure sounds awfully uncomfortable. But beyond that, I'm not really able to provide much insight.
I think that's well said, Dr. Harris. If we could go to tab 65 in our documents, please, Mr. Lund. These are the accounts and papers when we get to relative to the British colony of Vancouver Island and other colonies. And could I make this an exhibit, please, Mr. Commissioner?
Exhibit 1,146.
Now, if we switch over to the second page, or the first page of writing past the title page, part way down the page, Mr. Lunn, you'll note, there we go, the report at the Court of Windsor. This is the Colonial Committee dealing with the grant to the Hudson's Bay Company. Now, I note the people on the Colonial Committee. We have the Queen, we have her husband, Prince Albert. Do you know that the Lord Chancellor was the most senior official in England and the senior member of the Privy Council, the Judicial Committee? Dr. Harris?
I did not know that.
Did you know that the Duke of Norfolk was the premier Duke in English peerage?
I did not know that.
Did you know that Lord John Russell was the Prime Minister at the time?
No.
Did you know that Viscount Palmerston was the leader of the opposition and the next Prime Minister?
No.
Well, at the bottom of the page, and I've made that an exhibit. I think I have, haven't I? Thank you. At the bottom of that page, they refer to the grant to the Hudson's Bay Company, and on the next page, they refer to some conditions that should be removed. And partway down about the fourth line, they say that the grant of fishing of all sorts of fish in the seas, bays, inlets, within or surrounding the said island be omitted from the said grant. So a deliberate decision by the Queen, her most senior advisors and I believe the date is 1848, to strike the fishery from the proposed grant to the Hudson's Bay Company. That's correct?
That's correct. In an earlier draft of the grant, it had included the fishery, that the Hudson's Bay Company would take the fishery as a proprietary interest, and that was removed.
So now we have I'm sorry for the quality of this document. It's the next page, Mr. Lunn. We have the decision to exclude the fishery from the grant. And it might be easier for me to read it, and I apologize for the copy. Mr. Commissioner, I'll try and provide a better copy when we, in short order. It says, by the draft of the charter is then proposed, the whole of the fisheries in the neighborhood of Vancouver's Island would have been exclusively confined to the company. It was perfectly monstrous that the Colonial Office for a moment have entertained such a demand, and still more so that Earl Grey would have approved of such a proposition. We have before us a copy of his letter approving this monstrous monopoly. Why, it was a wonder they did not call upon the government for powers to exclude colonists from the very air they breathed. This provision has now been altered, and the fisheries are left as free as the air. So that gets us to 1848. Obviously, a lot of interest with the Colonial Committee and in Parliament about maintaining and protecting the public right to fish.
Yes, the Hudson's Bay Company does not receive a proprietary grant to the fishery. That's correct.
So these events are an important part of the legal context of the Douglas Treaties. They took place 2 years before Governor Douglas signed the Douglas Treaties.
The Hudson's Bay receives its grant in 1849, and the Douglas Treaties, the first of the Douglas Treaties, are signed the following year.
So any doubt in your mind whatsoever that Governor Douglas was fully aware of the decision of the Queen, the Colonial Committee, and the response in Parliament?
I'm quite certain that Douglas was aware of the limits of the Hudson's Bay Company's grant, yes.
Yeah. And then I think you're quite familiar with the papers, and I won't bring you to it. The Hudson's Bay Company then sent out a prospectus advertising that everybody would have equal free access to the fishery. Is that correct?
The prospectus indicated that landholders would have access to the fisheries. That's correct.
Okay. And a grant of an exclusive commercial fishery by Douglas to the treaty bands would be inconsistent with the decision of the Colonial Committee, the response in Parliament, and the prospectus of the Hudson's Bay, would it not?
Not necessarily. This prospectus applied to an incoming settler society. It didn't apply to Aboriginal peoples who were here already.
One of the controversial issues.
I think that's quite clear. The prospectus was intended as a document to attract settlers, primarily from the British Isles. And it was intended as a document to attract those settlers. was a statement of the rights that they would enjoy. It was no reflection of the rights that Aboriginal people would enjoy.
Thank you. I'd like to move on to page 10 of your document. And you're discussing the prosecution of a couple of a certain amount of Aboriginal fishermen fishing who signed on with one cannery and then left to a different cannery. Now, in that, up a little bit higher, you say there's 600 to 700 license holders, almost all Aboriginal, in the first paragraph of that page. So if you look at it over a 10-year period, you've got about 6,000 to 7,000 relationships, contractual relationships with Aboriginal fishermen.
I'm not quite sure that all follows, but yes, in the 1880s,
very large number.
The fleet was primarily made up of Aboriginal fishers who were selling their fish to the canneries from New Westminster south or downstream along the Fraser. And the point that I was making there was that the nature of the relationship had changed. A relationship that had been based on trade. Native people had taken advantage of the opportunity that the Hudson's Bay Company presented to sell fish to the Hudson's Bay Company. It was a trading relationship. The relationship that had once been based on trade had now become, by the 1880s, one based on employment law, that what Aboriginal people were selling was no longer their fish, but rather their labor. And as the sellers of their labor, they were subject to the employment law of the day, and the employment law of the day was the law of master and servant, and the law of master and servant provided criminal sanctions for breach of employment contract. And so Native people were being jailed for as I say, acting as traders rather than acting as employees.
I understand. I looked at you say in a series of cases in the mid-1870s, several fish processors. I went to your footnote and I found 4 cases in 1887 brought by a single fish processor.
1877.
Or sorry, yes, 1877. Was there more cases than there was listed in your footnote?
Those are the only ones that I'm able to identify.
So then a series of cases in the mid-1870s, several fish processors, would be an error in your paper?
No.
But you don't have any evidence that anybody else was prosecuted?
So I believe I have evidence of 4 cases that is several involving several different fish processors and several different Native people, some of whom were jailed as the law of master and servant allowed for an employee who breached his employment contract.
You don't remember that your footnote only listed the Hurling processor as the one processor who brought charges against 4? Okay, we don't have to go to it. You can probably fill in some other stuff while you're looking. Was it also accurate that another fish processor provided legal counsel? Okay, you can't.
I can't remember the parties that's exactly involved. I know a fellow, Samuel Herring, and another fellow, Henry Holbrook, both of whom were fish processors, both of whom were...
Okay, thank you. If we could quickly move, I'm running out of time, Mr. Commissioner, if we could quickly move to page 11. You note that by this time there was license limitation. A lot of licenses were controlled by canneries, not that many independent licenses. Is that correct?
Which time are you referring to?
Over at page 11, and you write, of these, most worked under a cannery license. According to the testimony of George Chehalis, only 40 Aboriginal fishers held independent licenses. While we're doing that, if we can go to tab 45 of our documents, please, Mr. Lund. So this is the time when there was a limited number of independent licenses. Have I got that correct?
So in 1889, the Department of Fisheries introduced the first limited license regime on the Fraser River. There were to be 450 licenses, no more, of which I believe it was 300 were to be allocated to the, or 400 to be allocated to the canneries, 100 to independent fishers. So at this moment, and it's a brief window, 3 years, there's a limited license regime. During that brief window, most of the canneries on the Fraser are held by the canneries. Most of the licenses on the Fraser are held by,
And
but
Cap-
not all are held by the
Yeah.
canneries. And after that and before that, the licenses are held by independent fishers.
And Captain, at page 45 of that document, please, Mr. Lund. And
Mr.
Captain
Commissioner,
George...
I'm sorry to interrupt Mr. Eidsvik. I rise because Mr. Eidsvik's been allotted 25 minutes. He's now gone just a little bit over that. We are very tight for time, and I regret that we really don't have any wiggle room today. I'm going to suggest that we take a short break if that's agreeable, Mr.
If I could finish the point first, Mr. Commissioner. Yeah. At tab 45, tab 45 and page 45. Now you note that Captain George of the Chehalis is very unhappy with the lack of independent licenses. But I note in here you don't say anywhere else that anyone else is unhappy. Yet at page 45,
I'm not following the page numbers.
oh, I'm sorry. You're right. They're awful pages. I think in the expedition of time, if I could list this, enter this document as an exhibit, please.
What is the document?
It's Ralston, tab 45.
Before you do that, tab 66 you referred to, I don't know that you marked it.
Yes, please.
Yes. Tab 66 will be marked as 1,147. Tab 45 will be 1,148.
Now, I bring you there if we had more time, but Ralston also talks about this appearances before this committee, and he refers to a parade of fishermen, both white and Indian, complaining about the lack of independent licenses. But I note that you don't mention anywhere else that anyone other than Aboriginals was affected or complained. Why would that be? It seems to me it was a victory for all fishermen when they got that restriction removed. White, Aboriginal, Japanese, they got away from the canneries.
Which restriction? That when the Department of Fisheries ended the experiment with limited licenses?
That's correct.
I think it's fair to say that then independent fishers of whatever background now had access to a fisheries license.
So it wasn't just Aboriginal fishermen that were disturbed by the policy. It was virtually all the people who wanted to be independent.
That's correct.
Yeah. Mr. Commissioner, it is the time for the break, and I've gone over my time. Thank you. I'm about a quarter of the way through what I had to do today, and it's one of the reasons why I had problems with entering the document, because a serious document like this I just can't deal with in 25 minutes. Thank you, Mr. Commissioner.
Thank you very much.
Hearing will now recess for 10 minutes.